Only about 10 cases.
Okay, it's funny we say only.
You know what? Let me take that back. Let me take it back.
Question: have all members of the Public Defender's Office had the opportunity to interview their clients? Do we know?
I have spoken with all of my clients except for one that is position number 2.
Okay.
He is on the medical floor.
Okay. Thank you, Ms. Wells.
You're welcome.
And Miss, I don't want to pronounce it incorrectly, Elwanger, is that correct?
Yes, Your Honor, that is correct.
And you have a wonderful first name. You must be a very wise person.
Yes,
Have you had the opportunity to interview your client?
yes, Your Honor.
Okay.
We are ready to proceed.
All right, we have 1 minute. We'll allow everyone else to get on the line and then we'll proceed. Thank you, everyone. All right, the time is now 2 p.m. We're going to go ahead and get started. This is the State Expedited Accusations calendar in the State Court of Fulton County, Georgia. I am Judge Melanie Williams, and today is June 28th of 2023. Our defendants, you have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have the right to an attorney at this proceeding. As you can see, I'm conducting this proceeding over the internet. It's being recorded and broadcast as a live stream. That means any member of the public can log on and watch. When I ask if you understand your rights, those are the rights to which I am referring. All right, who do we have first at courtroom 2?
Good afternoon, Judge Williams. It's going to be position number 8, Ms. Smith.
All right, and Ms. Elwanger, who do you represent?
I represent Miss Smith.
All right, Ms. Elwanger, who do you represent?
Chance Majumdar.
Is it possible for us to take that position next? All right, good afternoon, Ms. Smith. Your case number is 23CR004049H. In this case, you're charged with reckless conduct. Do you understand your rights today?
Yes, ma'am.
All right, thank you. Ms. Nimini, please proceed.
The events happened June 27th, yesterday at 360 Far Road. Officers arrived at the mentioned location. They found Jair Smith, a 2-year-old, alone in the home in a closet for an undetermined amount of time without food, water, or supervision. Additionally, the child's ribs were showing. So the state is asking for a $20,000 surety bond, no further contact with Mr. Jair Smith, unless in compliance with DFACS, no alcohol, drugs, or weapons. And I would like to sound if the witness is present, Your Honor.
Who's the witness? The officer?
No, it should be Mr. Chase Pruitt.
All right, is Mr. Pruitt present? And Ms. Nimini, if you could just briefly explain, Mr. Pruitt allegedly came onto the property and discovered the child. Is the allegation as stated by the state?
Yes, Your Honor.
Okay, understood. All right, Ms. Kim, please proceed.
Yes, Your Honor. My client, Miss Smith, is 29 years old, and she is actually residing in an apartment that is on her name, and her father is co-signer, and her boyfriend or slash friend, who is a father of the child, comes in and out a lot. So they have been taking care of the child very well. My client denies the allegation, and my client says that her son is very healthy. They went to all the doctor's appointments. He is just a little bit skinny and tall, just like his father, who is 6'4". And she has been here in Georgia for more than 4 years, and she's working as an Uber driver, and she's responsible. So she's not going to be qualified for public defender services. She also has a bachelor's degree from Seattle, Washington. We would like to request for signature on bond, definitely not more than $1,000 good bond. Thank you.
All right, thank you. And I am gonna sound for Mr. Pruitt one additional time, because I saw some people log on. Okay. At this time, the defendant received a $10,000 surety bond. She's to have no contact with the alleged. What were the initials of the alleged victim?
JS. Oh,
JF?
yes. Yes,
Thank
Your
you.
Honor.
Please have no contact with the minor JF unless in compliance with any defects orders. Additionally, she's to have no drugs, alcohol, or weapons as a condition. Is there anything further?
Nothing further.
No, Your Honor.
Usually we have an attorney that's going next. They got a private attorney case. They want to go next.
Excuse me, Your Honor, did you say there was 2,000 or 10,000?
I said 10,000.
I'm sorry, you went out again.
Hold on, Ms. Bridgewater.
Okay,
I had this problem on Monday. I don't know what's going on.
okay.
Oh, I put it to Mr. Howard. I'll start chatting you, okay?
Thank you.
Okay, if I can find you, there we are, Holly. All right, are we ready for the next case?
Yes, actually, medical is requesting, I don't see them logged on, but they are requesting to go next, but however, they're not on the Zoom, so we can go next with the private attorney case.
Okay.
Position
I'm
number 5.
And I'll take medical right after Ms. Elwinger's case. All
Thank
right. All right, good afternoon, sir. Pronounce your last name for me.
Majumdar.
All right, Mr. Majumdar, your case is 23 CR 004051E. You're charged with driving erratic and lane change and DUI. Do you understand your rights today?
Yes,
Is
ma'am.
that a yes? Okay. And I have the, okay, Mr. Howard, the history, please.
It's his second arrest, 2021, furnishing possession of alcohol below legal age out of Cobb. That was dismissed.
Okay, thank you. Ms. Stafford?
Yes, Your Honor. This incident occurred on June 25th, 2023 at 2 a.m. Officers observed the defendant driving on Georgia State Highway 400 in northbound traffic. The defendant failed to maintain a single lane of traffic as he crashed into the sidewall. After the accident, officers observed that the defendant exhibited difficulty concentrating, droopy eyelids, drowsiness, slow, deliberate movements, had difficulty walking, as well as there were times when he was incomprehensible. Due to the severity of this accident and the dangerousness that it could pose to the general public, the state is currently recommending a $4,000 total surety bond, $3,000 for the DUI, $1,000 for improper lane change, no driving except to work, school, lawyer, medical, no alcohol, drugs, or weapons.
All right, Ms. Elwanger?
Thank you, Your Honor. My client is 20 years old and he has resided in Roswell with his parents his entire life. He will be returning to their home once he is released from custody. Your Honor, he did once he was taken to the hospital after this accident, and the police informed him that there was a warrant, and he turned himself in timely. And he and his family retained me. In that case, Your Honor, we would ask for, and given his lack of criminal history, we would ask for a UJR. No issue with the no alcohol or drugs, of course, and the driving for the stated purposes would not be an issue for him either, Your Honor.
All right, thank you, Ms. Elwanger. At this time, defendant will receive a $2,500 surety bond, 500 count one, 2,000 count two for the DUI. I will accept the special conditions as listed by the state. No driving without a license is issued by the DDS, and only driving to the limited places such as school, work, medical, legal issues. Additionally, he's to have no drugs, alcohol, or weapons. Is there anything further?
No, Your Honor.
And Ms. Ellinger, does that conclude your business?
It does, Your Honor.
All right, you can be excused. Take care. Have a great afternoon.
Thank you, Judge.
All right, we wanted to take medical next. Who's that medical?
Yeah. This is going to be position number 6, Your Honor. Mr. Quavy.
Okay, this position's been reset a few times, so I'm glad we're able to take it today. And Mr. Quavy has not heard his rights, I'm assuming?
He did not.
All right, Mr. Quavy, your case is 23 CR 003960Y. In this case, you're charged with battery in a public train station with the offense date of June the 22nd. You have an absolute right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney, and Ms. Kim is present and available to assist you today. As you can see, I'm conducting this hearing over the internet as a live stream. It is also being recorded. That means any member of the public can log on and watch this proceeding. Do you understand all of that, Mr. Quavy? Yes, you understand? Okay. Yeah, all right, thank you. All right, Ms. Nimini, please proceed.
You want the history?
Oh, I do. I'm sorry, Mr. Howard. Didn't you say first?
No.
Oh, not for this position. Okay.
23 total.
Okay.
Last arrest was March 2022, Pittsburgh. Burglary, theft by taking, ag assault. 2021 assault excluding sexual, and a 2017 disorderly conduct conviction.
Okay. Thank you. All right, now, Ms. Nimini, please proceed.
Thank you, Your Honor. This event happened June 22nd of this year at 435 West Peachtree Street in Atlanta. The officer was at the location, and he witnessed a defendant intentionally punch Mr. Juan Perez Ortiz, the victim, in the face, causing him to bleed from his mouth. Defendant also told the officer that Mr. Perez Ortiz had verbally insulted his mother, and he deserved, and I quote, deserved to be situated. The state is asking for the original bond was 2,000 surety. The state is asking for 4,000 since he is a multi-state offender and he has previous offenses involving violence. Additionally, no further contact with Mr. Perez Ortiz, 1 day anger awareness, and no alcohol, drugs, or weapons. And I would like to sound for Mr. Perez Ortiz if he's present.
All right, I'm sounding for Mr. Perez Ortiz. Hearing and seeing none, Ms. Kim?
Yes, Your Honor. My client, Mr. Quavy, is 22 years old, Your Honor. Actually, he is, after completing his GED, he was working at warehouses and he has a certification to be a forklifter. He's also a tattoo artist. However, he has not been able to obtain any job for the last few months. So he is financially very, very challenged. He's qualified for public defender services. And right now he's staying at his friend's place, but he does not have anybody around him to bail him out financially. So he would like to request for a signature on bond. This is his first offense ever here in Georgia. He did not have any trouble ever since he came to Georgia. He wants to start fresh. He wants to have an opportunity to start fresh. And we would like to request for a signature on bond on behalf of him. If not, Your Honor, if you're not inclined to give him a signature on bond, we ask for $2,000 plus $1,000, total of $3,000 to be set as it was already ordered. Thanks.
Okay, let me clarify. He only has the one charge, or are you all seeing two charges? I have that he only has a one charge battery. Is that correct?
I didn't see any NOD for criminal trespass, but
Ms. Nimini, was that NOD?
I have a ag assault from this year.
No, not the history. Does he have more than one charge right now?
No,
On
Your
this? Okay, the only charge that we see remaining, Ms. Kim, is this battery.
Okay,
So the bond will remain as set at the 2,000 surety, and he's to have no contact with Mr. Perez Ortiz. Additionally, have no drugs, alcohol, or weapons as a condition. Is there anything further?
No,
Is
Your
there
Honor.
a stay away?
I don't think there was, what, did the state request to stay away?
Your Honor, Your Honor, Your Honor.
Mr. Quavy, please, you have a right to remain silent. We don't want to say anything that will hurt your case. You're more than welcome to call me and I'll be happy to explain everything to you.
But I just want to talk to the judge. I just want to say something to the judge.
What do you want to say, Mr. Quavy? Please do not incriminate yourself.
No,
What
ma'am.
Tell me.
Your Honor, I just ask, please, if I can just get released, please. I don't even know the witness. I don't know the victim. Your Honor, I am not from here. Like, I'm not a bad person. I haven't gotten into any trouble down here. I just, please, if you could just let me go home. I promise you, I stay on Stanton Road. Please, Your Honor, please. I assure
Okay,
you.
Mr. Quavy, for now it will remain set, but if you've heard of me, sometimes I will take your cries into consideration. I will think about it till the balance of the calendar. For now, the bond will remain as set at the 2,000, all right? But I will consider your request.
Your Honor,
Yeah.
if I can interject, can we have it, the state does want to stay away from the Civic Center station for MARTA.
Okay, does he have any other active MARTA suspensions?
Not that
Nothing.
Okay, so the only stay away that will apply will be that Civic Center, all right? And Mr. Quavy, I will take it into consideration, all right?
Your Honor, I would like to mention one more thing. He does have a chronic disease that he really have to get continuous medical attention. I would like the court to consider that as well. Thanks.
Okay. I will, I do take these things into consideration. I will keep his case in my mind as we go through. All right, for now, that concludes Mr. Quavy's case. Who do we have next?
Position 10, Walker.
All right. Mr. Walker, your case is 23 CR 004055J. In this case, you're charged with theft by taking. Do you understand your rights?
Yes, ma'am.
Mr. Hart, can I have that history, please?
Fourth arrest. Last arrest was on the 22nd. Simple battery trespass out of Spalding County. That's open, and he got an open theft by receiving. And a 2011 arrest for menacing. That's it.
I'm sorry, what did you say, 2011 what?
Menacing.
Oh,
It's in another
menacing.
state.
I thought you said medicine. All right.
No.
That would have been a new one. All right, Ms. Nimini, please proceed.
Yes, Your Honor. This event happened February 12th of this year at 4990 Jonesboro Road, Union City, where the defendant works. Defendant took Mr. Austin Kirkland, the victim's Apple AirPods, out of Mr. Kirkland's vehicle, a 94 Pontiac Bonneville, while it was impounded at the defendant's place of work, which is a tow yard. The state is asking for a 3,000 surety bond to stay away from 4990 Jonesboro Road, Union City, which is also known as Southside Record Service, no alcohol, drugs, or weapons. And the state also wants to put on record that the defendant the pending felony is from the same time period as well.
Okay, just to be clear, he's alleged to have taken iPods, and what was the other item?
For the felony?
I'm talking about for this particular case, it was just the iPod?
Yes, ma'am. Yes, ma'am.
AirPods, I'm sorry. Okay, all right, thank you. Ms. McLeod?
Yes, Your Honor, good afternoon. My client is 34 years old. He tells me that he was arrested in Spalding County in February under warrant, which made the same allegations, that he bonded out, and he's currently out on bond concerning this matter. So it seems to me that this is a duplication of the same case for which he was arrested in Spalding County. My client tells me that he is currently employed. He does live here in Fulton County. He does not make a lot of money, Your Honor, so he's not in a position to post bond. Also, this incident is alleged to have happened sometime in February. My client has no significant criminal history, so I would ask the court to consider giving him a signature bond so he can get out of jail, also taking into consideration that he was already arrested based on these same allegations. It seems inequitable to ask him to again pay bond on the same set of allegations. So I would ask the court.
One time, I didn't mean to cut you off, Ms. McLeod, but does anyone have information as to whether this is a duplicate charge, Ms. Dimony, or perhaps Ms. Falk? Can anyone see if perhaps he was booked in the same, if this is a duplicate?
Your Honor, I can look at our system and see. I'm unaware of that, but let me take a look.
It sounds interesting, but based upon the locations, but let's at least check. All right. Ms. McLeod, did I cut you off? If you weren't finished, please continue. You're muted, Ms. McLeod. Ms. McLeod, you're muted. We still can't hear you.
Sorry, Your Honor.
Please continue.
At the time of his arrest in Spalding County, he was told that it probably should have been in Fulton County. So nevertheless, he had to make bond in Spalding County. And it seems as if it's the same set of allegations, again, based on what he told me. So it does sound like it is a duplicate, Your Honor. And also it did happen. The allegation is that this took place in February. We are now almost at the end of June.
All right. At this time, defendant will receive a $500 surety bond. He's to stay away from that location on Jonesboro Road if he's not employed there.
He's no longer employed there, Your Honor.
Okay. And he's to have no drugs, alcohol, or weapons. If we receive information before close of calendar that this is a duplicate, we will revisit this position. But for now, the 500 surety will stand. All right. Best of luck to you, Mr. Walker. That concludes your case at this time. Who do we have next?
Thank you, Your Honor. May I be excused?
Yes, you may, Ms. McLeod.
Thank you.
Position 7, Redmond.
All right, good afternoon, Mr. Redmond. Your case is 23 CR 00405-2G. In this case, you're charged with battery, family violence. You understand your rights?
Yes, ma'am.
Mr. Howard?
Fourth arrest, 2019 battery out of East Point, 2019 probation, 2015 burglary first offender.
Okay. Thank you, Ms. Stafford.
Yes, Your Honor. This incident occurred yesterday at 72 Milton Avenue Southeast in Atlanta. Officers were dispatched to a dispute/fight with a weapon call to that location. Upon the officers' arrival, they met with the victim, Ms. Maya Gillum, who stated that her boyfriend had came home early and beat her. She also stated that this is not the first time that he has hit her, and she has made prior reports, but he would leave before the police would arrive. She informed the officer that the defendant had a gun and he had made threats to use it prior to the officer's arrival. Officers were granted permission to go into the residence, at which time they called for the defendant to come to the front. When he appeared, he had a black bag hanging across his shoulder and chest. When asked if he had a firearm, he stated that he did, and it was in the bag. When asked about the incident, he advised the officers that the argument got physical and the injuries that the victim sustained were due to her stopping him from leaving the apartment. Our office was able to make contact with the victim, who stated that she would be here at the hearing today. So at the appropriate time, we asked that you sound for her. She stated that she is not afraid of the defendant and wants to have contact with him and wants him to return to the residence. However, Your Honor, due to the fact that this incident occurred yesterday and there has not been an adequate amount of time for them both to cool off, our office is asking that you set a 70 bond, no further contact with the victim, Ms. Maya Gillum, stay away from 72 Milton Avenue Southeast, anger awareness, no alcohol, drugs, or weapons.
And I'm sorry, I could not hear the amount. What was the requested amount, Ms. Stafford?
$7,500.
$7,500. All right, thank you. I'm sounding for Ms. Gillum at this time. Ms. Gillum, if you wish to make a statement, I saw you on Zoom. You turn on your camera and raise your right hand so that I can place you under oath.
Is it on?
It's on. Please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes.
All right, you can put your hand down. What would you like to tell me at this time?
Okay, so I just wanted to say that Jonathan is not a bad person at all. He's been going through a lot mentally, family, and he doesn't deserve all of this. I do think it's best that we do stay separated, just because we have both a lot going on. We live together. He is involved in our my child's life. He's been going to classes to get his behavior back right. I mean, he lost his job. His life was literally just crashing in front of him. So he was just losing his mind and a lot financially going on. So he's not a bad person. He cleared up his whole entire record. He did all his probation. He did all his classes. He's in his nieces and nephews' lives. So I don't want him in jail. I just think that anger management probably would be best, but he doesn't belong in jail.
All right. Thank you. I appreciate you coming to court and making that statement. I do appreciate it. Ms. Kim, please proceed.
Yes, Your Honor. Mr. Redmond is 25 years old and he was born here in Georgia, raised here. Your Honor, my client told me that he was actually employed as a commercial landscaper. He's been doing that for the last 5 years. And because of his employment, I disqualified him for public defender services. So I would like to confirm that with my client about that. However, he graduated from high school and he does not have any child with Miss Maya Gillam, even though they do have a child that he is actively involved in. That's not his biological child. Your Honor, my client does not have any objection to stay away or no further contact with a client. We would like to request for a signature on bond, or if Your Honor is not inclined to give him a signature on bond, we ask for a maximum $1,000 good bond. Thank you.
All right, thank you.
Can I confirm with my client about the job? Mr. Redmond, do you have a job?
No, I know I just lost it.
Okay.
All right. All right,
Thank you.
Defendant will receive a $2,000 surety bond. He's to have no contact with the alleged victim and stay away from that location. He can return one time with a member of law enforcement to get any items. Additionally, he's to have no drugs, alcohol, or weapons. And as a reminder, he'll be reset to the state all-purpose calendar on July 11th, whereby contact and other provisions of this bond can be revisited. Is there anything further?
Nothing further, Your Honor. Thank you.
All right. Best of luck to you, sir. Who do we have next?
Position 3, Javon.
Your Honor, while they're bringing up Mr. Javon, can we let the courtroom too know that Mr. Tolbert will be entering a plea? I have emailed the plea paperwork over.
Is it a pro se plea?
Yes, Your Honor.
All right. All right, Mr. Javon, your case number is 23 CR 004054A. In this case, you're charged with terroristic threats. Do you understand your rights today?
Yes.
All right, Mr. Howard. Oh, I'm sorry, first arrest, so we will go straight to Ms. James. Ms. James, please proceed.
Yes, Your Honor. On June 27, 2023, officers responded to 5552 Cascade Hills Loop in reference to a terroristic threats call. Upon arrival, officers spoke with the victim, Miss Sandra Jovan, who advised that she and her husband, the defendant, were in a verbal dispute, and that Ms. Jovan also stated that they were in a verbal dispute because of Mr. Javon's sister. She stated that all parties were at the residence and that the defendant started breaking multiple items in the residence, as well as, putting a hole in the wall. and that the defendant broke the bedroom door upstairs, and that there were multiple kids there at the time, and that he stated that he was going to burn down the residence on tomorrow. And so she stated that she didn't feel safe at that time, and she didn't know what he was capable of doing, and that was the reason why she called the police. And she's since stated that she is afraid of him when he gets angry, and that they need a cooling off period. And that she would not like any contact with him at this time. She wants him to stay away from the location. And she would like for him to have the 1-day anger management and have a one-time police escort when he comes to get his belongings. And the state is requesting a $3,000 surety bond. I think there was a $10,000 surety bond on that charge, and no alcohol, drugs, or weapons. And I don't know if the victim is on, but if you would sound for her.
Can I have the stay away address again, please?
It's 5552 Cascade Hills Loop in South Fulton.
Okay. And I am sounding for Miss Jovan or Jovane at this time. If you're present and wish to make a statement. Oh, there's a lot on the. Hold on 1 second.
Sure.
What? Okay. All right. Ms. Jovane is not here. Ms. Wills, please proceed.
Thank you, Your Honor. Mr. Jovane is 31 years old. He is employed by CKS, and he works with their maintenance department. He has been employed there for 1 year. He will not qualify to be represented by the public defender's office. He has a high school diploma as well as an associate's degree. He has a 2-year-old child, and yes, he previously or already has a bond of $10,000 on the terroristic threats and acts. I would ask for a signature on bond, as this is my client's first arrest. In speaking with him, he has no objection to staying out of the home and finding alternate housing. I did also speak with Ms. Jovane, who did say that her preference was for them to not have any contact. And so my client does have somewhere else where he can go. He does deny the allegations as alleged. He does admit, though, that a door was broken, but that was only because it was locked and he was attempting to get his things and belongings out of the room. But he maintains that the actual argument was between his sister and his wife, and he had asked both of them to leave due to their incessant arguing. I would also ask for a one-time law enforcement escort for him to gather his things, and third-party visitation with the 2-year-old child that he shares with his wife. And that is all, Your Honor.
All right. Defendant will receive a $3,000 signature bond per judge through pretrial services. He is to stay away from the incident location. He can return with law enforcement one time to get any items. He's to have absolutely no contact with his wife during the pendency of this. Additionally, he's to take the 1-day anger awareness course and have no alcohol, drugs, or weapons. He can coordinate transport of his child by contacting a third party. Is there anything further?
No, Your Honor, thank you.
All right. Best of luck to you, sir. Who do we have next?
Position 4, Jules. Come on, Mr. Jules.
All right, Mr. Jules, your case is 23 CR 004048G. In this case, you're charged with theft by shoplifting. Oh, he's not here yet. Please hurry. Do you understand your rights? Is that a yes?
Yes, ma'am.
Thank you, Mr. Howard.
36 adult arrests. Last was December 2022. False imprisonment, simple assault, PI. On probation for those charges out of state court as of March of this year. 2020 burglary conviction, 2020 trespass conviction, 2020 petty theft conviction, 2019 carrying concealed weapon, resisting officer conviction, 2018 probation, 2017 battery conviction, 2015 trespass conviction. and a dangerous drugs from 2015.
Okay, that's sufficient. Thank you. Ms. Nimini?
Yes, Your Honor. This incident happened June 27th of this year at 142 North Main Street in Alpharetta. Officers spoke with the manager at that particular location of CVS. Defendant had entered the store, proceeded to exit the store with a frozen meal, 4-pack of Red Bull, and some Taki chips, which equated to about $19.27. The theft was captured on video surveillance, which the store manager was able to identify that the defendant and the officer was able to also look at. Considering that the defendant is a multi-state offender between Florida and Georgia, committing crimes very closely together, the state is asking for a $1,500 surety bond, stay away from the location, no alcohol, drugs, or weapons, and an anti-theft course.
And the amount of what he took equated to about $19?
Yes, Your Honor.
Okay, thank you. Ms. Kim?
Yes, Your Honor. Mr. Jules is 37 years old and he was born in Florida. However, he came to Georgia when he was 18 years old, 2005, around 18 years. He was working at Willie Mexican Grill as a cook and server. He's been working there for about 6 months and he graduated from high school and he has one class from the college and yet he could not complete. Your Honor, he is currently receiving Social Security income because his income from Mexican Grill is not sufficient. He's qualified for public defender services. We would like to request for signature on bond. Usually theft by shoplifting, they get signature on bond. However, if Your Honor is still not inclined to give him a signature on bond, we would like to request for a $100 good bond. It is for $19.67. I'm sure that he will be willing to pay for it if he stole, but I don't think that he's denying the allegation, Your Honor. We would like to request for signature on bond. Thank you.
Defendant will receive a $3,000 SOB through the jail. He's to stay away from that location and have no alcohol, drugs, or weapons. Anything further?
Nothing further, Your Honor.
All right, best of luck to you, Mr. Jules. Who do we have next?
Done. Position 9, Tolbert, he's taking a plea.
Is he the last position there?
No, he's not.
Can we do the plea last if possible?
Come on, Mr. Brown. Position 1.
And Your Honor, sorry to interrupt. I have an update for you on the Walker Henderson case.
Okay.
I did reach out to Spalding County Clerk of Court, spoke to the court, and they do in fact have a felony warrant for him on the gun case. They do not have a warrant for him for the misdemeanor. I am reaching out to the DA's office to alert them so they can proceed accordingly because they do have duplicate felony warrants.
All right, thank you, Ms. Falk. That's very helpful. File will remain as said in that case. All right, I'm sorry, this was position 1?
Position 1, Mr. Brown.
Okay, Mr. Brown, your case is 23 CR 00401 F in which you're charged with battery. Do you understand your rights?
Yes,
You said yes? Mr. Howard, can I have the history, please?
Open case in Superior Court for entering auto. He got open obstruction and trespass, a couple of those in state court. He got a total of 130.
Okay. We'll go to Ms. James. Ms. James, please proceed. If this is your case. Ms.
Yes,
James?
it is.
Oh, okay.
It is. I was checking to see if I was muted.
Okay, no problem.
Your Honor, this incident took place on June 25th, 2023. Officers noted that when they arrived, they saw the victim, Paul Williams, laying on the ground with blood coming from his nose and his face was starting to swell. They also noted that he had contusions on his face. And Mr. Williams stated that, this is what Mr. Williams told the officers, that the defendant was selling cigarettes. He asked the defendant for a cigarette and said he would exchange $1 for the cigarette. Mr. Brown, the defendant, gave him a cigarette wrapped in a paper towel. When the victim, Mr. Williams, asked what it was, he told him it was a cigar. Mr. Williams told the defendant that he wanted his money back and he didn't want a cigar. So the defendant threw the money on the ground. And when the victim went to bend over to pick up the money, that's when the defendant came from behind him and struck him on, with a closed fist, and he fell to the ground, and they, a fight started. There's a passerby that informed the officers that who the defendant was and gave a description, and that he's the passerby, the witness said that once they were on the ground, they began to fight, and that one of them grabbed a book bag, emptied all the contents, and took only what they wanted and left. And because, Your Honor, of this extensive history, the state is going to ask for a $7,500 surety bond and no further contact with the victim. And we ask that he stay away from that location on 1080 Peachtree Street Northeast in Atlanta, and that he has no alcohol, drugs, or weapons.
All right, I'm sounding for Mr. Williams. Hearing none, Ms. Will.
Thank you, Your Honor. Mr. Brown is 53 years old, and he is someone that our office is familiar with. I've already requested that a social worker go out and visit with him. We do not believe that an MHE is appropriate at this time. I would request a signature on bond, and if Your Honor is not inclined to grant a signature on bond, I would ask that he be placed on the next competency calendar if he is given a surety bond.
Without evaluations, he cannot be placed there, Ms. Wills. So do you wish to, are you requesting that at this time?
I'll have to talk to Mr. Howard about how he would like me to proceed in that case.
All right. At this time, defendant will receive a $3,500 surety bond. He's to have no contact with Mr. Williams and stay away from that location. Additionally, he's to have no drugs, alcohol, or weapons. He will be reset to state all purpose July 11th. And we're also going to put down that he needs a BHET at this time. Is there anything further?
We release on the surety bond.
Yes, you received a surety bond today. If you speak to Ms. Wells, she can assist you, okay?
That means they're gonna let me go today.
Please give Ms. Wells a call.
Thank you.
All right, who do we have next?
Your Honor, I just wanted to.
Mr. Tolbert, come on, Mr. Tolbert.
Before we go to the plea deal, Your Honor, I wanted to make sure that Mr. Cuevai, position number 6, I know we only addressed the simple battery. There was a warrant for possession of marijuana as well. So can we please have an NOD for that? Because I don't want my client to be stuck in a jail because of that another case that was not addressed. Because I didn't see the NOD, Your Honor.
Okay. If someone from the state could take a look at that, please. Thank you.
Thank you.
All right. All right, Mr. Tolbert, your case is 23 CR 004050Y. In this case, you're charged with criminal trespass with the offense date of June the 27th. Do you understand your rights today?
Yes, ma'am, I do.
And it's my understanding that you wish to take a plea today, unrepresented by any member of the Public Defender's Office?
Yes, ma'am.
Did you have the opportunity to speak with the Public Defender's Office prior to this?
Yes, I did, ma'am.
And you feel confident to represent yourself today? All right. Is this your case, Ms. Falk?
No, it's Miss Nemene's, and I would just request her to put the facts on the record. And the state's recommendation is 12 months probation, 1 day in jail, credit for time served, release time served, The balance of his probation will be suspended, and he has a restriction to stay away from all MARTA stations until, and I believe the date was March 16th of 2024, which is concurrent with his restrictions that were already given to him by MARTA.
He already had a ban. Okay.
So all we just need is the facts on the record.
Okay, thank you, Ms. Falk. One question. He was booked in on this charge yesterday.
I believe so, yes, but I can double check.
I just want to make sure he's not going to have any additional time. All right, Ms. Nimini, very briefly, please put the facts onto the record. And then, Mr. Talbot, I'll ask you a series of questions to make sure that this is a voluntary plea today, okay?
Yes, ma'am.
Ms. Nimini, please proceed.
Yes, Your Honor. This happened June 27th at Lyndhurst Drive and MLK Drive, Junior Drive. Officers responded to the mentioned location. Defendant knowingly and intentionally boarded the MARTA bus 1558 on Route 66 on the second block when he was banned off MARTA property for 365 days, which was issued on February 16th of this year, and it went into effect March 17th of this year, and it stays in effect until March of 16th of 2024. The state was recommending.
Your Honor, that's all for that's our recommendation. And I will say that he has been in jail for 1 day.
Okay. Are there any additional facts we need to highlight, or can we move forward with the plea? Okay, hearing none,
we're ready to proceed.
All right, I think we have a good flavor of what took place. Mr. Talbot, please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes, ma'am, I do.
All right, you can put your hand down. I'm going to ask you some questions as I explained. Because you don't have the assistance of an attorney, I'm going to ask more questions than I normally ask, okay? And you understood again that you do have a right to an attorney, and if you spoke to an attorney, you might end up with a different offer or something different, but you're choosing to represent yourself today. Is that correct?
Yes, ma'am, that's correct.
All right. Are you under the influence of any drugs or alcohol at this time?
No, I'm not, ma'am.
Are you satisfied with your attorney's you don't have an attorney. Again, you understand that you're proceeding pro se and you wish to move forward without an attorney.
Yes, ma'am.
Okay. And you understand that you're giving up the right to have the state prove these charges against you beyond a reasonable doubt by taking a plea at this time?
Yes, I do.
And you understand you're also giving up your right to a trial by judge or jury?
I understand that also.
And you're giving up your right to have the state to present any defenses you may have had that might have resulted in the dismissal of this charge?
Yes, I do.
And you understand that the time you served in the Fulton County Jail should close out your case. However, you can't go back to MARTA until March of 2024. Do you understand all of that?
Yes, ma'am.
The specific date is March the 16th, so you can't go back there till then. You understand that?
Yes, ma'am.
Did anyone force you to take a plea?
No, they didn't.
Did anyone promise you anything in exchange?
No.
And you understand that if you're on probation for another case or you have any other matter open, your probation could be revoked because you pled guilty to this charge?
Yes, I do understand that.
And you understand that it may affect other aspects of your life that we can't anticipate, such as employment?
Yes, sir.
All right, as to the charge of criminal trespass, how do you plead, Mr. Talbot?
I plead, I mean, guilty, no law.
No, do you plead guilty or not guilty?
I plead guilty.
All right, I'm sorry, Ms. Falk or Ms. Nimini, did the state previously agree to allow him to plead no law?
We did not, Your Honor.
Okay. So, Mr. Howard, do you have his history by any chance?
Yeah. This Tober, right?
Yes.
31 total. Last arrest was in Cobb County on the 25th of this month, probation.
Okay, well, that's yeah. All right. So,
Okay.
Mr. Talbot, do you plead guilty to the charge of criminal trespass?
Yes, I do.
All right, I accept your guilty plea. Is there anything further? from either party of the state of defense? Well, there is no defense, but from the state or Mr. Talbert?
Nothing further, Your Honor.
All right, that will conclude your case, and I hope that the jail will be able to get the paperwork to us in a timely manner. Before we, if courtroom 2 can be excused, however.
Your Honor, I have that paperwork already.
That's what I was about to say. Thank you, Ms. Bridgewater.
And is, number 2 is a medical reset, is that correct?
Yeah, I was just getting ready to tell you, position 2 is gonna be a reset, due to they refused.
Okay, wonderful, thank you. Courtroom 2 can be excused. Mr. Howard, I saw that message. I am not inclined to give that person a signature bond through the jail at this time. Does anything further need to happen?
You want to change up bond order to a good bond?
No, I wanted to let him out of jail and have him be mine. Yesterday, as part of state all purpose, there was a gentleman who was released on an SOB through pretrial. He is now refusing. Is he's still in the Fulton County Jail?
Yeah, he not going nowhere unless you sign that paper.
Okay, well then it will remain that way.
I mean, I didn't know if you wanted to put him back on another calendar because he's just gonna rot. He gonna sit. Nobody going out nowhere if they ain't signing no paperwork.
Your Honor, if I may, we have had this issue come up before. Can we reset him 2 weeks on the SAP so that if he does not sign the paperwork, we can revisit this? Because we have had a gentleman who things went a little long before we realized he had not signed the necessary paperwork.
Right, I don't want him to get, I really want him to get out now.
But
the pretrial does have the requirement that he has to sign the documentation.
I understand. I'm trying. Do you, by any chance, do you have his history, Mr. Howard? You'd probably know.
I mean, I can look it up real quick. Let them do the. They can go over.
Okay, yeah.
We'll do
Ms.
it.
Bridgewater, please review. That was a difficult case yesterday. Anyway.
Okay. Once again, the reset date for the SAP calendar is going to be July the 11th. Position number 1 is going to the SAP calendar with a $3,500 good bond. Position 2 is medically reset till tomorrow. Position 3 is reset further notice with a $3,000 SOB through pretrial per judge. Position 4 is reset further notice with a $3,000 SOB through the jail. Position 5 is going to the SAP calendar with a total $2,500 good bond. Position 6, SAP calendar with a $2,000 good bond. Position 7 is going to the SAP calendar with a $2,000 good bond. Position 8, SAP calendar with a $10,000 good bond. Position 9 took a plea, and position 10 is going to the SAP calendar with a $500 good bond. Are there any questions, comments, or otherwise?
Yes, what was number 2? It's a reset, but is there a bond on that?
No, it's reset till tomorrow. It'll be heard tomorrow.
Okay.
And did Ms. Kim get a copy of the NOD for Mr. Quavy?
Yes, I got it from Miss PD Falk. So I mean, that's the ASG.
Okay, wonderful. Mr. Howard, please let them know that I am gonna, the signature bond will remain, and if we can find a way to put it on state all purpose, not for 2 weeks, that one is already full. It'll be the state all purpose after the 11th. So what would that be, the 18th, if he could be placed on that state all purpose calendar? Ms. Bridgewater, say that again.
Wait just one moment. I'll check, Judge. Let me look at the calendar.
And Judge, I do have a question as to position 1. I forgot that Ms. Burgess, one of our social workers, said that Mr. Brown was previously on the competency track. And so he recently had a mental health evaluation that should still be good. And then just looking in Odyssey, he was just on the competency track like last November.
Okay, so we'll associate those cases. All right. But I'm still concerned about this other one. We'll put, he can go to the, is the 11th?
Do you want them on the July 11th calendar?
Is there still space?
Let's not do them like that. Let's put it on the 13th. Yeah, let's put them on the 13th.
The 11th already had so many positions.
Yeah, it has over 60 cases. So let's put them on the 13th, which will be, what, 3 weeks from?
Okay, so Mr. Brown needs to go there as well, since we've heard he's on the competency track. He needs to go to that Thursday, the 13th. And the other case that Mr. Howard has will be put on state of, Mr. Edwards, Alton Edwards needs to also be placed on state of purpose on the 13th.
You don't want to amend the bond order?
I don't.
Because, I mean, even if he signed, he probably not going to show up because he don't want to sign it no way. But he may figure out, I'll just sign it so they can let me go. I mean,
Well, that's fine. That's what the
well,
clerk.
that's not good, Judge. That's not good.
Why is it not?
Because he needs to show up.
Okay.
He's going to be
So
a
let me
headache for
ask you
everybody.
something, Your Honor, position number 1, Mr. Rico Brown, you want him, instead of going to the SAP calendar for the 11th, go ahead and put him on the 13th as well? Is that what you're telling me?
If you see a pending eval, do you see that he already had an eval in process? If so, if he's already on the competency track, then he needs to stay there.
Okay,
Typically,
I'll look and
though,
see.
okay, if he does not have if he's not undergoing an eval, we can't put him there. But
Okay, no problem.
Can I hear number 1 again?
Number 1,
Yes.
he has a $3,500 good bond, no further contact with Paul Williams, to stay away from 1080 Peachtree Street, and a BHET.
Thank you.
You're welcome.
Okay, Mr. Howard, please give me a call regarding that case, and then what I'll do is I'll think about it, because it's really a charge he should not be sitting in Fulton County Jail. He needs to get out of there. And he was almost willing to take a time served plea. So, okay, let me think about it. Just will you please give me a call? Thank you.
You want me to give you time to think about it?
Yes.
I don't want to call immediately because you ain't thought about it.
Okay. Don't call me too late. I'll be done. Take care, everyone. We will be in recess until tomorrow's SCA calendar.
Okay, I was just informed that Mr. Rico Brown does not have an evaluation pending.
Okay, then he doesn't go to the competency track and he goes to that July 11th. If
That is correct. Yes, ma'am.
He can be reset.
And Your Honor, just to kind of follow up on that, I think what was being said is he had a recent evaluation.
Yes.
I'm actually seeing that a final disposition was entered on his previous case, November 17th, 2022, in front of Your Honor, where we null-prossed that case. So what I think they're not saying that he's undergoing an evaluation, just that he's had an evaluation so recent.
Had one in the past. Okay.
Yeah.
Okay. So Miss Bridgewater, keep him on the competency one. Okay.
No problem. So we're looking at July 13th.
This job is never boring. All right.
Never.
Never boring. Okay. Mr. Howard's gonna give me a call. Take care, everyone. You'll be in recess. We'll be in recess until tomorrow's SCA calendar.
I'll call about 3:15.
Okay. Thank you.
All right. Thank you, Your Honor. Have a good day.
All right. Take care, everyone.
Bye-bye.
Bye-bye.